Today on Tony's Legal Corner, we're going to talk about the difference between a Baker Act and a Marchman Act. And we're also going to talk about how a Baker Act and a Marchman Act leads to incompetence, and how the procedures of being Baker Acted and Marchman Acted, how they differ and how they are the same. Stay tuned. The Baker Act and Marchman Act are both Florida statutes that allow for involuntary intervention in situations where individuals pose a danger to themselves or others, but they address different issues. The Baker Act focuses on individuals with mental illness, while the Marchman Act focuses on individuals with substance abuse issues. Now, as I was telling you before, there's a difference in how they're viewed. So one is if, say, like you're an alcoholic or you're addicted to prescription drugs, you could be Marchman Acted. But if you have a mental health problem, let's say they claim you have PTSD or schizophrenia, and let's say that PTSD or schizophrenia causes you to claim that you're going to kill yourself or somebody else, then you could be Baker Acted. If you have a substance abuse problem, you could be Marchman Acted. All right? So either way, you could be involuntary committed. So I'm going to show you the process of involuntary commitment on both. I always show y'all through the law. I don't like to do like different websites and all that because it may confuse you. So I take you straight to the actual law. So criteria for a person may be taken to a receiving facility for involuntary examination if there is reason to believe that the person has a mental illness, and because of his or her mental illness, the person has refused voluntary examination after conscientious explanation and disclosure of the purpose of the examination, or the person is unable to determine for himself or herself whether examination is necessary, and without care or treatment, the person is likely to suffer from neglect or refuse to care for him or herself. Such neglect or refusal poses a real and present threat of substantial harm to his or her well-being, and it is not apparent that such harm may be avoided through the help of willing, able, and responsible family members or friends, or the provision of other services, or the substantial likelihood that without care or treatment, the person will cause serious bodily harm to himself or herself or others in the near future, as evidenced by recent behavior. Right? That is statute 394.463 of the Florida statutes. Now I'm finna get into involuntary Marchman Act. All right. I got all these. Okay. And this is Florida Statute 397.675. Criteria for involuntary admissions, including protective custody, emergency admission, and other involuntary assessment, involuntary treatment, and alternative involuntary assessment for minors for purposes of assessment and stabilization, and for involuntary treatment. A person meets the criteria for involuntary admission if there is good faith reason to believe that the person is substance abuse impaired or has a substance abuse disorder, and a co-occurring mental health disorder, and because of such impairment or disorder has lost the power of self-control with respect to substance abuse and is in need of substance abuse services, and by reason of by reason of substance abuse impairment, his or her judgment has been so impaired that he or she is incapable of appreciating his or her need for such services and of making a rational decision in that regard. Although mere refusal to receive such services does not constitute evidence of lack of judgment with respect to his or her need for such services. And I'm stopping right there. Continue to listen. Continue to watch and listen. The reason why I wanted to show you those two procedures or those two statutes is because in the state of Florida, people don't understand how the law works and how the legal process, particularly because everything that I'm trying to show you goes into probate and estates and how the state of Florida treats people who inherit property, particularly black people who inherit property, such as myself. So the reason why those two statutes are important is because those two statutes are being used against me as far as my grandmother's estate is concerned. So I'm going to explain that to you. In one of my videos, I showed you the procedures of declaring somebody incompetent. And what I told you was when the courts in Tallahassee deemed me incompetent, they didn't do it properly. Now, what's going on is, and this is why I'm being chased by the property appraiser and all these people, is because what they want to do, when I came home, they wanted to set the stage for me to have a mental health problem. That is the reason why I was initially Baker acted in 2014. You understand? They set all that up. Why? Because they want a paper trail of leading to a mental health disorder. So you have if you don't know what a paper trail is, that is when people, the government or whoever, creates a trail of plainly papers that suggests something about somebody. So in my case, they have a trail. They have a trail of papers that suggest that I have a mental health problem. From me being Baker acted all the way to them arresting me 12 times and then trying to declare me incompetent. That is their paper trail to lead to me having a mental health disorder. Now, part of the reason why they tried to do that is because of, one is my grandmother's estate, but the other part is because I'm a veteran, they believe that they can use me having a mental health disorder to claim benefits from the VA. And you can't do that. And in my next video, I'm going to show you, that's when I'm going to start to show you in detail, like certain mental health disorders, post-traumatic stress disorder, and these other disorders, schizophrenia and things like that, and how it is diagnosed in the military versus how it's diagnosed in the civilian world. And I'm going to show you exactly the laws from the VA that govern doing a VA claim for PTSD or any other mental disorder. I'm going to show you in detail how that works. So, deuces.